Okay, so I'm going to start going. We're going to try to have questions at the end, but if there's something that just can't wait and is very important, please raise your hand and we'll try to take that question as it goes. So one of the forms of immigration relief that we see a lot of young people qualify for is something called Special Immigrant Juvenile Status. And this is an immigration status which involves certain determinations which are made by state courts as well. So that's oftentimes where family court comes in, as Lenny was talking about, into our immigration story. What SIJS, as it's often called, is a gateway to critical educational, medical, and employment benefits for children. So in short, it's a way for children to obtain what's called lawful permanent residency, which is a fancy term that means get a green card here in the United States. A green card is a path to becoming a United States citizen, and that would enable the child to vote and have full citizenship benefits just as anybody else who was born in the United States would. Okay, oops, sorry. Okay, so who qualifies for SIJ, this Special Immigrant Juvenile Status? So SIJ is available to children who are under the age of 21, who are unmarried, and that a juvenile court has determined cannot reunify with one or both parents, and I'm emphasizing the one or both because that's key here, because of abuse, abandonment, neglect, or other similar bases under state law, and whose best interests are not served by returning to their country of origin or last habitual residence for those children who are effectively stateless. Okay, the sources of law where this comes from, we have what's called the TVPRA. That's what Lenny talked about before. That's the Trafficking Victims Protection Reauthorization Act that came into law in 2000 and then was subsequently reauthorized the most recently in 2013. But this really comes, the SIJ as we see it now, is from the 2008 TVPRA. If you go home tonight and you're really interested in this and you're Googling around and you see things about SIJ that are pre-2008, please beware because the law really changed in 2008 to the benefit of a lot more children. Before 2008, it was really focused on children who were living in foster care, and it was seen as a way to help those children who were in state foster care. Now it's a bit broader, and so we just ask that you use caution for anything pre-2008 just because the law has changed. Okay, regulatory authority, we have all that here in case you're interested. And the regulations, our federal regulations, as you know, they're a little bit behind, so those have not yet been modified to reflect the changes from the 2008 TVPRA. So they're a little bit behind, and that's why this all gets a little bit more complicating, is that we have various regulations and various memoranda, all that coming in to teach us how to interpret special immigrant juvenile status. So we mentioned that there needs to be a juvenile court or state court determination. In New York, the courts that are appropriate here are the family court, the surrogates court, or the Supreme Court, or if you're not familiar with New York law, that's our trial level court here in New York. We talked about that the child needs to be dependent on the court, which means quite simply that the court has taken jurisdiction over the child, and the child needs to be committed to or in the custody of state or an individual entity appointed by state or juvenile court. What that kind of confusing phrase means is that this can also include foster care placement, juvenile guardianship, custody, even delinquency placements. So we're seeing special immigrant juvenile status, kids able to access that through a variety of different court processes. So this is not just for kids during a custody proceeding or a guardianship proceeding. It can also be a destitute child proceeding, which is often for children who are in foster care or entering foster care. Can also be children in delinquency proceedings as well. Okay. We have the idea that reunification is not viable. So this is the idea that these young people cannot reunify, so cannot reestablish that relationship, key here, with one or both parents. And that's due to abuse, abandonment, neglect, or similar basis under state law. So in terms of that similar basis, that might sound bizarre. Where I've personally had that applied in a case is for children whose parents had disappeared. They were fleeing, they were literally running across a border from a different country, and her parents disappeared from her. She had not heard from them in 2 years. So this was not a willful act of abandonment, as we think about how abandonment is defined in our Family Court Act and in our social services law. This was her parents had disappeared during this traumatic event, and the judge had found that that was another basis under state law for her to qualify for special immigrant juvenile status. Okay. Then we talk about the best interest determination. This is a case-specific determination, and it involves a consideration of a of many different factors, including what the child says he or she wants. He or she wants to remain in the United States, to continue living with this person that is their guardian or custodian, educational opportunities, health opportunities, all of that comes into play here. And then finally, we have the age upon the application. So under the TVPRA, the applicant, so the child, must be under 21 at the time that the petition is filed. And we'll talk a little bit more, but we have this family court, this state court part, and we also have another immigration part here. And that's immigration, not the immigration court, but part of our Department of Homeland Security, which is one of that branches there is referred to as USCIS, which is the United States Citizenship and Immigration Services. It's our benefit side of immigration. So the actual petition for Special Immigrant Juvenile Status after the family court part has been done has to be received by USCIS before that child's 21st birthday. So there's a lot going on in terms of dates to be aware of with SIJS. Okay, here's more examples of the state court proceedings. And then talking guardianship is the most common way we see children able to access the state courts and therefore able to access Special Immigrant Juvenile Status. There are benefits to guardianship for both the guardian, the proposed guardian, and for the young person. We've listed some here, including care and guidance, so on and so forth, but also the idea of having documentation. Being undocumented does not prevent someone in New York State from being a guardian for a child. There are very clear benefits to having documentation that shows that legally established relationship in terms of, especially in terms of a single parent guardianship or when it's a single parent custody case. If that mother, for instance, or that father doesn't have a custody order and that child needs a passport from the home country, in many countries it is impossible to get a passport without the signature of both mom and dad. That's not going to happen. And therefore the child can't get a passport and can't get identification documents because of that. So you have a whole list of benefits to guardianship and custody and so on and so forth. These are just a few of them. We just wanted to make sure you're aware of that. So in guardianship cases, the proposed guardian can file a petition for guardianship, but also a child over the age of 14 can file this petition for guardianship, him or herself. Some courts here in New York, in different counties in New York, as Lenny was mentioning, we work with children throughout the 5 boroughs of New York, also out on Long Island from Nassau and Suffolk counties, also up into Westchester, to Orange County, to Putnam, Dutchess, so on and so forth. So we have a lot of different family court situations going on here. And in some of those courts, the court will also appoint an attorney for the child from their panel, even though the child is saying that they have their own pro bono counsel. That's fine. We don't want to step on anybody's toes, and we're happy to help you to actually co-counsel with that attorney for the child, because what we find is it actually makes for a great relationship. The attorney for the child is thrilled, most likely, to have you on board to help him or her with work, because they've got a lot of other cases going on, and it's a learning experience for them to oftentimes learn what Special Immigrant Juvenile Status is, so that hopefully their antenna will go up for the next case they have to see if perhaps that child also qualifies for this while that child is already in family court for a guardianship, for a custody, or for some other kind of proceeding. Okay, so the whole goal of the family court proceeding that the child has entered into is to obtain letters of guardianship or final order of custody, or some other reason why the child is in court. And the second part of that is to obtain something that's called a special findings order. So this is really a point where you, as the attorney for the child, would come in to make a motion, and that's a written motion to the family court, explaining why the child qualifies for what's called a special findings order. This is an order which is actually a form. It's one of the family court forms. It's GF 42, General Form 42. But what it is it's a form that lists, it's for the judge to sign, but it lists out all the elements of Special Immigrant Juvenile Status. The judge needs to, essentially, the court needs to sign this form for the child to be able to apply to the benefit side of immigration to USCIS for Special Immigrant Juvenile Status. Okay, so what is going to need to be articulated in your motion and on the record is that that child is under the age of 21, is unmarried, has been abandoned, abused, or neglected by one or both parents, that it's not in the best interest of the child to return to the child's country of origin or last habitual residence, and that this court has taken jurisdiction over matters concerning the child. Okay, so typically there's a hearing involved in which your witness would be your child client and also perhaps the proposed guardian or custodian to just clarify the picture for the court. The goal is at the end of this proceeding that you have letters of guardianship or a custody, order of custody, and that also this special findings order that you have not one but 2 copies of it, just in case immigration loses one, you've got a backup, right? And you don't have to go to family court and wait for it and try to explain why immigration lost it. So you have that form, and with that you're able to help the child to file what's called an I360 petition, which is a form that you need, the form for Special Immigrant Juvenile Status. Okay, so what I've explained is probably a confusing mess to you, and that's perfectly okay. That's why we have more in-depth trainings, and that's why myself and my colleague Guillermo are here to guide you through this over and over again, because it is confusing, and we understand that, and nobody gets it just from talking about it in 5 minutes. What we want you to take away is that this is a form of immigration relief for children that involves a state court process as well. So it's also explaining to the child that they're going to need to go to family court or to surrogates court or Supreme Court, whatever situation is applicable, in order to obtain this, to have a guardian appointed, in order to obtain this order that hopefully that they be able to use to apply for immigration benefits. Okay, so now hopefully you're at the point where you can file this I360 petition. Those forms are all available on the government's website, and again, there's no fee associated with this, with the filing of the I360. The form I360 is used for about 12 or so different processes for applying for immigration relief, including the Violence Against Women Act and including petitions for Amerasians, and there are also for religious workers. And so you will see on the form that it's asking for a fee. That's for people who fall into those categories. For children under Special Immigrant Juvenile Status, and the form says that, but just to clarify, there is no fee involved in this particular form. Okay, and then these are just, you need to file with a proof of age. That's typically the birth certificate and a translation. All documents going to immigration and to the family courts and our state court system as well, they need to be translated, and that doesn't have to be a translation where you pay money for it. We have a whole bunch of volunteer interpreters who are happy to translate documents for you as well. Okay, so after you've received a receipt notice for filing the I-360, you are able to terminate removal proceedings in the immigration court. And that might be changing a little bit. We're on a couple of different listservs where we're hearing a little bit of pushback on that, but how it's been going in front of the particular judge that we're in front of is that she will accept that with the receipt notice, so with the notice that immigration gives you saying thank you for filing, that you can make either a motion, an oral motion, motion, or a written motion if you don't want to come back to court and if you just want to get it done to effectively terminate the child's removal proceedings. That means ending the deportation case against the child. That's huge. That's a really big deal. So that's great, and so that's another step in this process. With the order from the judge terminating the removal proceedings, you can then actually file for a green card application for the child. So this is the I-485 Adjustment of Status application, which is an application for lawful permanent residence. That means getting a green card. Okay, so we just put a couple notes up here that immigration conducts full criminal and security clearances prior to adjudications. That means that the child will be fingerprinted at immigration. It's very important to talk to all of your clients, but especially young people, especially teenagers, just to make sure that there's been no interaction with the police. Special Immigrant Juvenile Status waives a lot of minor criminal issues, but you need to be aware of them, and the child needs to be aware of them, because as we all know, what you don't know can hurt you, and when you're in immigration land, not knowing those things is a big deal. I like to break it down and literally ask my child clients, have you ever seen a police officer? Have you talked to a police officer? When you ask someone if they've been arrested, while that may seem to a very straightforward question to you, yes, you've been arrested or not, it's actually not. We have all kinds of stop and frisk things going on, and it's really not clear during that proceeding who was actually arrested and who was not. So the child might not be lying to you. He or she might not actually know that that was an arrest and that that was important to talk to you about. So break it down into the, like, have you spoken with a police officer? And then, so that's what I would encourage you to do. Okay, there are certain what are called grounds of inadmissibility in immigration law. Those are, and we have all those listed for you. We decided that this presentation wasn't appropriate to get into all of those, but what to take away is that Special Immigrant Juvenile Status, SIJ, waives a lot of those grounds of inadmissibility. That's great. And then for those young people whose grounds of inadmissibility still apply, there are certain waivers, and a lot of them are the young people are able to access those as well. Okay, there are substantial fees, over $1,000 in filing a green card application. We have been successful at fee waivers, which are explanations to the government that you cannot afford to pay the fee for these young people in SIJ cases. So please, please ask us before asking your client to pay over $1,000 to the government for the filing of this application. Some fees that cannot be waived are fees for to a doctor who's called a civil surgeon, and that's someone who has an agreement with immigration to do a medical exam, which is required for everybody applying for a green card in the United States, and the fees that the individual person has to pay to get 4 passport photos taken, and that should be about $10 or $20. Okay, so this is just a picture diagram. We have the family court, we have USCIS, the immigration benefits side, where you're actually filing the I360, the SIJ, the Special Immigrant Juvenile Status Petition, and then after the termination, the end of the deportation, the removal proceedings, you will actually be going back to the benefits side of immigration to file the adjustment of status, which means the green card application. Okay, so Special Immigrant Juvenile Status, one form of relief for young people.